Thank you for coming together. This is a wonderful opportunity to learn more about a very, very important aspect of our lives as faculty members. That is how to move forward with inventions and how to ensure that our inventions are protected and it is done in the right way for the right reasons and it's positioned properly. This is the first formal meeting of the CSULB chapter of the National Academy of Inventors. And I'm very, very pleased to introduce our president, Dr. Jane Connolly, to address us in this momentous occasion.
Sure, thank you very much. Your president, who is not an inventor and is actually in awe of all of you who figure new ways to make the world a better place. So thank you for the invitation. And welcome to this first event. I was with you last year as you formed the event, as you formed the chapter here. I understand we're still the only CSU chapter of the NAI. I like all those. I like to know that when we're the first and clearly the best. And I know that many in this room are among the most important innovators in our region. I know that because Dean Golshani constantly tells me how wonderful his faculty is and how wonderful his students are. So it goes on and on. So I hear it all the time how great you are, and I'm glad to be with you today to actually learn more from Wayne. And welcome, Wayne. Welcome back. I know you've been a great friend of the college. You know, I'm particularly excited when I read about some of the work you do that I see that many of you are working on making the world a better place for people with particular challenges as well as all the other work that you do. So I'm proud of you. I'm looking forward to the presentation. I generally would come to almost any meeting that has pizza, so keep that in mind. If you want me there, just say pizza and I'll be there. So I'm looking forward to enjoying the presentation with you. So thank you and go Beach.
Thank you, President Conley. It's always a pleasure to have you with us. And with this, I'm going to introduce John Breivik, who is the Vice Chair of the chapter and the host of this meeting, and he will introduce the speaker. John? Professor of Mathematics, not engineering. Thank you.
Thanks, Borzan. Thanks to Amita, thank you so much for all of your help. And the facilities folks have been so great in setting this up. It's my great pleasure to welcome you all to the very first of what I hope is going to be many events that are put on by our chapter. And it's especially a great pleasure to welcome Wayne Howe, who leads intellectual property strategy and protection for Boeing's Network and Space Systems business. Wayne's education includes an MS in computer science as well as a master's combining his interests in electrical engineering, music, and radio. So clearly an interesting guy. He's got a Doctor of Jurisprudence with a certificate in intellectual property. He's done all the core coursework for his MBA, and he's had a career including the founding of 2 startups, 30 years in advanced technology development, R&D, intellectual property, and has 27 issued U.S. patents with 17 pending, has been protecting inventions for over 25 years in large, medium, and small companies. Please welcome Wayne Howe.
Very nice, thank you. Well, I'm going to wander back and forth just a little bit. Can you all hear me? That's always the negative question. If you can't hear, how do you know? Okay, so I am flattered. Thank you very much, John, and I'll walk on. Okay, I did look up the National Academy Inventors, and these are their mission and goals, and frankly, I was impressed. There's lots of encouragement of inventors, enhancing their visibility, encourage the disclosure of intellectual property, and that's one thing that I'll focus on. Because if you can have all of this innovation, but if you don't think of it as property and then protect it as property, it doesn't give you any value in return for all that innovation. Educate and mentor innovative students and translate inventions to the benefit of society. So I thought that was pretty cool. So what's intellectual property? It's any sort of concept, some idea that you have that you can translate into a medium material sort of medium. So we've got drawing, software, tech know-how, recordings, videos, market insight, writings, images, business processes. All of these are intellectual property, and they all have their own unique way of being protected. And these are the four, I wonder if this works. Yeah. So these are the four types of intellectual property. All of this is IP, and these are the ways of protecting it. Patents, trade secrets, which I'll get into patents a bit. Trade secrets, very little. Trademarks, I'm going to skip. And copyrights, which seem to be a little bit more relevant to you all. So I think patents and copyrights really is going to be the focus. And if you would like any further information, please let me know. I've got some cards up here. So if you just take a technology, in the middle here we've got an engineering model. It could be hardware, software, operating system, a piece of metal, as if it's got some unique capabilities. So that's where you start, and out of that, coming from a startup background, all of these different types of things can be generated from that engineering model or that technology. We've got marketing, product launch timetable, business plan, methods, processes, source code, graphics, logos, your company name, algorithms, flowcharts. And each one of these has some sort of protections. For example, flowcharts, you can copyright, you can keep them a trade secret, or you can patent them as a method patent. I won't go into all of these, but even a business plan you can keep as a trade secret, or you can copyright it. So all of this, this is sort of almost looks like a flower. From that technology, out comes capabilities, and from that comes ways to protect it. So that's what IP is, and there are four types. This is where we're going to focus a little bit. What is a patent? Well, it's a grant that's issued by the USPTO. It doesn't give you the right to do something, it gives you the right to exclude others from doing something. Within the U.S. territories and possessions, up to 20 years from the filing date. So I'm going to tell you a little story. Let's see what my time is here. This is a personal story. It's about my grandfather. I call him Grandpa. When I was a little boy, I'm sorry, I just keep hitting the buttons when I was a little boy, my grandpa turned to me and said, I heard that he had an invention. So I asked him about, what sort of invention was it, Grandpa? And he said, well, let me tell you the story. I was an engineer, and I worked for an engineering company. We built bridges, we built big buildings, and one day my boss said to me, I want you to go over to this bowling alley, and back in those days they had pin boys that picked up the pins, moved the pins that were knocked down out of the way, and you were supposed to put the pin exactly back where it was when you lifted it. So if the ball had moved it, you've got to put it exactly back where it was before you lifted it up. So he said, so I went around to the back and I looked at, they wanted me to rebuild some of these pin boy, they called them shacks, but they're really kind of like bunks. So he said, I went back there, it's got a very, very narrow aisle. So he was walking in the aisle, and then there's a bunk bed here, a bunk bed there, bunk bed, bunk bed. So he's going through here, he's got his notes, and he's measuring things and writing it down. And he said suddenly he heard a blood-curdling scream right behind him. He whipped around, and there were two pin boys running down this aisle. He's stuck right here. The first one is screaming bloody murder, and the guy behind him had a knife this long trying to kill the other pin boy. He says he doesn't know how it happened, but the first guy was able to get past him, and there he was between this guy with a knife and the other pin boy screaming, and he said, I thought to myself right then, there's got to be a better way. So I'm going to let you all guess. What was it that Grandpa invented? The automatic pin spotter. So, and he had 6 patents on it. I looked them up a couple of days ago. One of the things about his invention that was so, other people had tried to do pin spotters. One of the things that was unique is he had figured out this way that wherever the pin was, he could grab it, pick it up, and put it back exactly where it had been before. So that was one of the unique improvements. Okay, so what I'm going to walk you through here with Grandpa's invention. The grant was issued by the Patent Office. It gave him and his company, because he worked for a company, the right to exclude all others. And by the way, that company became AMF, American Mining and Foundry, yeah, AMF, which you'll see on whenever you go to a bowling alley, almost all of those have an AMF logo. Right to exclude others so that they could do it themselves, made a lot of money. Within the US, up to 20 years. At the time, it was up to 17 years. Okay, there are 3 types of patents. This first one is a utility patent. That's what Grandpa did. It was something that was useful, that it provided some sort of value in its utility. Today, those terms are 20 years from the date that you first file it with the Patent Office, unless you do some, patent law is complicated, so I want to make sure you all know that this is not legal advice. Boeing wants me to say that, and but that it's a lot of information about how this system works. So it used to be 17 years from when it issued, now it's 20 years from filing date. The next thing is a design patent. It protects an ornamental design. So you all heard of the wars between Apple and Samsung, I assume. They're in the billions of dollars, or I think $800 million, they lowered it. All of those were Apple's, or not all, but the majority of the ones that are real public and are the big dollar numbers were design patents that Apple had done on their iPhone. So their iPhone has and you describe it just a little bit, but you've got a picture. It's a rectangular shape with curved edges as a phone. That was unique. Nobody had done those as a phone before. So they were able to get the design patent. And and the next thing was they had a grid of colorful icons on a black screen. So Samsung came out with their line, and guess what? It was just a little bit longer, but still rectangular, still had the curved edges, had a black background with colorful icons on it. So that was the basis of that. Now I think it was $800 million, but it keeps moving around the courts. It's now back in an appeals court, and they're asking for cert to the Supreme Court. Anyway, that's a design patent, and you also can patent plants, inventions of new plants. And that's a very unique, sort of distinct field that most of the patent folks don't get into. But basically, if you invent or discover, not in a cultivated area, and can asexually reproduce, which means it doesn't have seeds, you got to sort of graft it together. You can asexually reproduce it, then you can get a patent on it if nobody's done that before. Okay, so then in 2013, the US changed their laws pretty significantly. It used to be for Grandpa that if he had taken notes about how he designed and built in the inventive steps in a notebook and had dated it and had somebody look at it and check it, and then someone else filed the same invention at the patent office, but they had invented it later than Grandpa still would have been able to get the patent because he had documented proof that he invented it first. So in 2013, all of that changed. The US patent laws changed to be in harmony with European and the rest of the world's, and it became a first inventor to file. So now if Grandpa had diddled around and hadn't filed in time, the other person that filed first would have gotten the patent as the first inventor to file. The focus being on file. So, message to the faculty, an inventor has to file the invention as quickly as possible before another inventor files the same one. It doesn't matter anymore who invented it first. It's who gets to the patent office first. And there's a dilemma with that, and we'll get into that in a minute with provisional patents. The dilemma is this. If I think of some great idea and I write it down and the next day, write it down and send it off to the patent office, it's likely that I won't have a very good description of that patent. And then when it issues, I'll just have the limitations of my first day's work. If I instead wait some period of time and every day I'm working on it and I get it so that it's very fleshed out, now I send in a very full patent. One of my patent teachers used to say, when you write a patent, you want to throw everything in, including the kitchen sink. Everything you can think about it, you want to write it down and get it into the patent office. Then when the patent issues, you can add different claims. You can play around with the claims to try to capture all the different stuff that you have in that patent. But if you filed it right away and didn't describe it, then you've got problems. Okay, if it's a provisional patent, which we'll get to in a second, doesn't need to get filed with claims. But if it's a non-provisional, meaning it's the full boat, that has to be filed with claims. Now, do those claims have to be the same claims as when it issues? No. You could write the specification. You usually need some sort of drawing so that it's understandable. And your claim could be a mechanism for picking up pins. And then you've got, usually the patent office takes 3 years between when you file it and when it issues. During those 3 years, you can file amendments to the patent after you've thought about it a little bit more and have more detail about how you want to have the claims read. You can amend the claims before the patent examiner examines it. So you've got some time in there, usually at least 1.5 years. That answer your question? Okay, so what's patentable? Well, what did Grandpa do? He had a new, useful, non-obvious machine, an apparatus. If you have an article of manufacture, meaning it's a product, something that a machine made, that's patentable if it's new, useful, and non-obvious. You can patent a composition of matter. You've got some new way of putting these basic elements or chemicals together. You can patent a process, so that's back to the flow charts. If you've got this new way, an algorithm that's a new way that this computer is going to be able to work, and it's going to, there's some complexity in patents for software and computers, but as long as it's tied to the machine and does some transformation of the data into it, then it's potentially patentable as just the process, as the flow chart, or a useful improvement on any of these that somebody else had done. So Grandpa's got his machine, it goes down and it sweeps them out, but somebody else comes along and tweaks something, they can get a patent on the useful improvement. What's not patentable? It used to be of saying everything man-made under the sun is patentable. So I'm not sure that's true, but it seems to be, it's floated around for many years. The laws of nature, E equals mc squared. So Einstein could not file a patent on his mathematical formula. Gravity, or some way of analyzing gravity. Now, well, let me just say, gravity is not patentable. The ideas are not patentable, but if you figure out some way to alter gravity or reconfigure space-time so that it curves just a little differently, then that's a mechanism and you can file a patent on something like that. Natural phenomena like water, salt, anything that already exists before people came along and made it. Now, if you modified water into something else or salt into some new chemical, then that's patentable. Abstract ideas are not patentable, and the patent office is really going after, really using this as a way to try to keep computer patents and software patents out of the public domain, or out of the patent office, patent world. That's, in some cases, they've got some rules that are changing daily by the way the courts look at this. But at this point, an algorithm is patentable. I'm sorry, an algorithm is not patentable, but if you have some way of putting it in a computer so that it modifies and transforms this information, then it can be, if it's new, unique, and non-obvious. So, this is some wording from the Supreme Court. When taken as a whole, the claimed invention must have additional limitations that amount to significantly more than this abstract idea. So if you've just got this abstract idea, it won't fly, but if you can do some other new, unique things with it, it's possible they'll let it in. Okay, so what are the three things that you've got to have about this new machine, product, etc., that will allow it to be patented? It's got to be novel, and there can't be any prior art. And by art, we mean anything that somebody's invented or described or put in a patent or published in a paper before. It's got to be novel, which means new, and there can't be any prior art. So you don't get a patent if it's already patented, if it's described in some kind of printed publication overseas. If it's in, it didn't used to be that way. It used to be just if it was published in the U.S., but now anywhere in the world, if it's in public use, meaning somebody's doing it somewhere, if it's even on sale. So let's say you make a product, you don't file a patent on it, you keep it in your garage, but you make a deal with somebody else to buy it. Under certain circumstances, that could be considered a bar to getting a patent. Otherwise available to the public before the effective filing date. So it used to be if you sold something in secret to someone, that still was considered on sale. That's been changed with this new AIA in 2013. Now, if you have a secret sale, it doesn't necessarily mean it's not patentable. Except that in the US only, you can get 1 year grace period for inventors if they publish or if they give a speech about it or in some way it gets released into the public domain. You, in the US only, can still get a patent on that if you can show that you were the original inventor of that idea that got published. Once a year has passed, no sale, you can't get a patent. And overseas, it's called an absolute bar. Overseas, once you in any way let it out into the public without a non-disclosure agreement, you're out of luck. You can't get a patent overseas. The way that this works is the patent is based on how it's done. So if you just see, let's say I've got this new cool thing, but it's inside this plastic egg and it makes the egg jump around. I can't, again, this isn't legal advice, but generally speaking, if you just see that egg, then you haven't publicly disclosed it, especially now that AIA has been passed. But if you open up that egg, then they've seen it and they may be able to figure out how it works, and you've just given away your rights. If you describe how this invention is going to work, yes, then it's a public disclosure. If you just say, I've got this great idea for these new kinds of rollable eggs, you didn't say how it works, So that doesn't bar you from getting a patent. It's based on how does this thing work and disclosing it through a patent to the public so that the public can use it, either licensing it from you or after 20 years, it's public domain, they can use it however they like. In the US only. So if you publish it anywhere in the world, then in the US only, you have a year in which to file a US patent. You can't get any credit for it overseas. It's going to boil down to, do you describe how it works? You could say to your investors or whoever it is that you're giving this disclosure or publication to, as long as you don't say how it works, if you just generally describe you've got this great cool thing and it defies gravity, but you didn't tell anybody how you defied gravity, then you haven't disclosed. It's got to be, the vaguer it is, the better off you are. The more specific it is, then, you know, in the end, it could end up in a court case and some judge and jury possibly decides, well, that's too specific. He published the how-to. The way that the government, I hate to be the lawyer type, it depends, but here are the basic parameters. If you have a DoD contract, then your capability is covered based on a whole bunch of regulations called DFARS, Defense Foreign Something Acquisition Regulations. Those DFARS say basically, if the government paid you, then they want either unlimited rights to it so they can do whatever they want, or government purpose rights to it, meaning they can do whatever they want in the government, but they can't sell it commercially. So it's going to depend on the terms that you negotiate in your contract with the DoD when you take their money. The other thing is, if you put your money into it and then the government puts some money into it, that's called mixed funding. Now you can keep it at government purpose rights so that the government can only use it for the government. Now Boeing, I could invent something for Boeing. I'm the inventor, and in your case I should say, you and the student would be the inventors. You would also, because of the way the DFARS are written, you would be the owners, but you would give a non-exclusive, unlimited rights to the government. There are some, it's not the DFARS, but there are some similar regulations for other government agencies. NASA's got a slight tweak with theirs, so yes, but I don't know what those differences are. So here's your out. You can have a non-disclosure agreement with whoever you do the proposal for. When Boeing submits something to the DoD, there's a law somewhere that says that they're supposed to hold that confidential. And therefore, you've disclosed it, but in private. If you disclose it publicly, that's where you start losing your rights. So you want to be as vague as possible and have a non-disclosure agreement in place if possible. And then I should say, excuse me, that and I'll get to a chart here that says, it all depends on the contract. So if you're an inventor and you come up with something and you have a contract, then you're the owner, you have all the rights to it, unless you have a contract with somebody that says you gave them your rights, like most people have to sign when they are in a company or maybe when they're in a university. There's some guidance from the UC system that I looked at, and there's some new IP guidance. I don't know if it's guidance or regulations, but it's some set of what universities are supposed to adhere to now. It's new. I don't know what it says. Jane? No, I'm just putting you on the spot.
Yeah, there's a new IP policy from the system. It's still in a consultation phase with CFA and and academic senates throughout the system, but that's the last phase, and it's very comprehensive. I don't know I do know that it will reflect the kind of negotiated share You know, if there's extraordinary university support or it was for hire, you know, you may have, usually faculty would have use of, but not, and they could bring it somewhere else and they could sell it, but there might be some split of royalties in some way. But that should be coming out before, probably in the fall. And it does set up a system-wide patent process. So it might become a little bit more codified in some way across the system.
No.
But there will be a real patent office at the system level.
So jumping back to Bayh-Dole, the university has a leg up with the Bayh-Dole Act, as long as it doesn't get changed now that I'm thinking about it. But the university, because there's public universities. Public universities, because there's public money going into that university, they sort of rearranged the rules so that the university has more rights than the company who's funding that research. And the way I understand it from what some of the Boeing interactions is, we can fund a university to do a study, and we may, under Bayh-Dole, walk away with no rights at all. And some sort of agreement that we'll be the first in line to try to negotiate rights, but it really weakens the industry's hand, and it strengthens the university's hand. So, and this is the most important thing on the chart: use non-disclosure agreements. Anytime you come up with this new idea, you don't want to be sharing it unless you're sharing it under NDA. So it has to be new, has to be useful, and there's the third fork. It has to be non-obvious. An invention may be obvious, and this is where, if it gets to this point, you definitely want to have a patent attorney help you, because there's all kinds of complexities in this obviousness argument. There's lots of ways for the patent office to try to argue that it's obvious, and there's a whole lot of arguments based on a lot of court cases that the patent attorney can argue back and say, no, it's not because X, Y, Z. Because the prior art that the examiner, for example, the examiner may say, well, that's not patentable because I have some prior art. You've got A, B, C, and I've got some prior art that says A, B, D. Your patent attorney can look at that and say, well, no, patent office, you have not shown us that you have prior art. This is still patentable. Some arguments can be made that really enhance the inventor's or the owner's rights in arguing back to the patent office on this non-obviousness. But the patent office is very good at using this to kill your patent, so you've got to have somebody that's good to do this. All right, and this is the way that the law describes this: the differences between the claimed invention and the prior art such that the invention as a whole, so it's not just a little piece part of the invention, would have been obvious before the effective filing date. So now they're in their minds, they're going to move back to when you invented this. That's your effective filing date. And would it have been obvious at that point to a person having ordinary skill in the art? Now, what's a person that has ordinary skill in the art? You all would probably not be people who have ordinary skill in the art. You have higher skill than ordinary. So there's this legally abstract concept of a person, even though there's no person like this, that has this ordinary skill in whichever art that you're in. Now, the patent office usually tends to push that harder, and then your patent attorney can push back to weaken that argument. All right, so there are two ways that you can file a utility patent. The first is a non-provisional, which, as I said a little earlier today, that's the full boat. That's everything all described as much as possible with claims that you submit, and then when it issues, the claims that you argue about back and forth with the patent office will issue, and those claims are what you'll own. So It's comprised of a patent specification, which is the written description, and it has to be full, clear, concise, exact. So it can't be vague, it can't be muddy and murky. It's got to very clearly explain how this thing works. It describes the manner and process of making it and using it, so it enables this person skilled in the art to make it and use it. And there are a lot of law cases where it was described so that you had to experiment around just a little bit to get it to work. And so then that was not, that didn't meet this written description of full, clear, and precise. The claims have to particularly point out, distinctly claim the subject matter. Again, there's no room for ambiguity. And drawings were necessary to understand. Now, it boggles my mind, but some folks have gotten patents without drawings. I don't understand how they can do that, but I think it's more flow chart type process method patents. And this full boat is expensive. That's what throws a lot of people and keeps a lot of people out of this. It's $10,000 to $15,000 or more for the patent when you talk about the fees to the patent office and especially the fees to the patent attorney. And then they have maintenance. Once the patent issues, every 3.5 years, you have to pay a maintenance fee 3 times, and it keeps increasing over time for your 20 years. So this is your temporary out, called a provisional patent application. That's what the dean was talking about just a minute ago. This is a way that you can get your idea in there at low cost so that you at least have put a stake in the ground at the patent office that you invented this. And this goes back to the previous discussion about you want to have as much as possible in that provisional. If you're skimpy in the details in the provisional, then a year later when you have to file the non-provisional, a full boat, within a year. A year later, if you refer and use this, all you'll be able to get this date on is this skimpy description. Then if your provisional adds more stuff to it, that date that if the non-provisional adds more stuff to it, the date that non-provisional gets filed works for that extra stuff, so that's the date it gets. The provisional gets whatever it described at its date. That gets complicated, but that's the way it works. But you can file this thing you don't have to write any claims. You can file it for $130 as a small entity. So I think it's $260 if you're a regular corporation. All right, so back to the danger thing here. You must, and within a year after you pay the $130 and put your provisional patent, you've got to file a non-provisional or the provisional will go abandoned. You want to make sure you have as much as possible in there, as well written as it can be in there. You probably won't have to pay as much because a person doesn't have to write claims, and the description, it's got to explain a lot of the how-to, but it doesn't have to have all the formalities of the normal one, like the abstract and some things like that. No, this is what I was saying. If in the provisional, you want to put every possible description of how this thing works instead of waiting when you file the non-provisional. So that's the danger side. If you don't file the non-provisional within a year, first of all, they don't publish your provisional, so nobody knows unless you refer to it, and then they let it out. But if you don't file it, it's just buried into the patent office. They probably put it in the digital shredder, and you don't have a patent. You could then file it again, but you wouldn't get that original filing date. That's important because then you establish that you're prior art to them. So they weren't the first. It's not novel and unique anymore because you had that filed. That is generally true. But if you then file a non-provisional that refers to that provisional, then they can search that and add it as part of what you've referred to, incorporated by reference, sort of.
Because I always thought that if you filed a provisional and then you abandoned it, basically you told the world, this great idea that I have, I'm not going to do anything with it, help yourself.
Nope, no. The world doesn't know unless you tell them. Now, there are ways that large companies that have patents that they aren't going to use can go through a process where they, in effect, make it public domain. So they've filed the patent, they've gotten it issued, and they decide they don't want to make money on it or they want to give it to the world. They can go through this process and then anyone can use it. But the provisional doesn't get published unless some patent refers to it. Okay, so when you file the non-provisional and it's sitting there for 18 months in the patent office and still nobody can search it then either, that's considered patent pending. And if you filed a non-provisional, you could put patent pending on it. I don't know if you can do that with a provisional or not. It's a great question. No, it's not illegal if you say it's pending because you filed something at the patent office. Now, it could come out that in the end the patent office rejects you, then you're not supposed to say patent pending on it if you don't get a patent. Okay, so here's the difficult balance. You want to put everything in that provisional, but you don't have time because you're trying to get it out the door. So you've got to make some smart decisions about when it's descriptive enough and big enough that you can file on it. Okay, now we're getting to IP ownership and rights. So we talked just a little bit a minute ago about the creator of the IP is the owner at that instant that they invent it. But if they have some other agreement that assigns their rights, they're under contract to the government or they've got some sort of deal with their investor, then they're still the inventor. And they have to be, in the US, they have to be listed as an inventor on the patent. In foreign countries, that's not necessarily true. But in the US, if the investor puts their name as the inventor, that patent can be invalidated. The US is very strict that the inventor's name needs to be on the patent as the inventor, and then whatever contracts that have assigned different types of rights, that's later, and you can file an assignments in the patent office if you like. You don't have to, but you can. So that's really the stickler here, is this agreement to the contrary, because so many places that employ you these days, especially if you're intellectual academic, they want some sort of rights. This is the policy on inventions and discoveries, and then this is my statement that it's not legal advice. Go to that website. Okay, I think we're done with patents unless you, and feel free to throw out some more questions about them as we go through copyrights if you want. One thing that you can do, this is not legal advice, is you can go to what's some people call them patent trolls, and sell or license your patent to them, and they have the millions of dollars to go to court to sue, but you're going to lose some rights and some money to that. They call them NPEs, non-practicing entities. They don't practice actually making anything. All they do is buy or license patents and sue other people to try to get them a lot of money and the inventor a little bit, usually. So there is that out, but it is a difficult situation. As an inventor, yes, I empathize. So a quick rule of thumb on trade secrets versus patents. That's not in here. If you have I'm going to use Boeing as an example. We have lots of technology. Trust me, man, it's a 150,000 person company, and I think there's 50,000 engineers. So we have lots and lots of technology that gets developed. One of our markets, and I'm in this network and space systems group, is we put satellites up in space and they float around, and it's very difficult if you put something in there for anybody to see it and figure it out and reverse engineer it. So would we file a patent on that? Probably not. We probably would keep it as a trade secret and then give the inventor some sort of award on the side. If anybody can see it and reverse engineer it, then you want to go down the patent road. You describe it in different levels. You start off with, usually patents start off with, what's the area of this technology, and then if some patent practitioners put in a section on prior art, but usually that's not a good idea. Then they just jump down and have broad descriptions of their patent and broad how it works, and then they have very brief descriptions of the drawings. Then they go into the section where it goes into all the little details and uses all the numbers that are on the patent drawings and describes exactly how it works. Then so there's really two levels in the description. In claims, patent practitioners write the first claim to be the broadest possible description of the invention, and then the second claim says, I claim the first claim, but that it also has XYZ, and the part C is a carburetor. So it gets more and more detailed as it gets farther along. The reason they do that is the patent examiner could come along and say, wait a minute, that broad claim, I can find somebody else that's done the broad claim. So then, but I can't find anybody else that's done the combination of claim 1 and claim 2. So the patent examiner in that situation would say, combine claim 1 and 2 and I'll give you the patent. So that sort of peeling the onion sort of upside down is how the claims are done. Copyrights. Let me ask you guys a question. If I take out my pen, or I'm going to do it this way. Can I get a copyright on that? Pardon me? It's already copyrighted. The moment you have pen to paper, whatever's on the paper is copyrighted. Anyone who does that, so I guess it's on the next chart, but this is the key phrase that the lawyers use, must be fixed in a tangible medium of expression. So here's another question. Suppose that I'm sitting at my keyboard and I type la 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 la. Is that copyrighted? Well, let's go to the rule. It has to be fixed in a tangible medium of expression. It just comes up here on the screen and I see the characters. Is that fixed? Some people would argue that it is, but what the key part is it's stored in memory somewhere, and that's a fixed tangible medium of expression. So generally when you type something on your computer, it doesn't just show up on the screen, it gets preserved in the memory, which then puts it up on the screen. So that would be copyrighted. Not the typing, the whatever it was that got put in memory that's copyrighted. Okay, protects creative expressions of, exclusive legal right, protects original works of authorship. That was an original work. And it given to an originator or an assignee. So again, this is my copyright unless I've got some sort of other agreement that says all of my copyrights go to somebody else. Then I can't do it. Let me just finish because I'm probably running out of time here. There's lots of different things that, print, publish, perform, fill, record, artistic, music, all of that stuff is copyrightable once it gets fixed into some tangible means. It protects the creative expressions, but not the ideas themselves, just like patents. And it must be fixed in the tangible medium of expression. So this is copyrighted once you do it. And then when this person comes along and puts it in a tangible medium of expression, meaning digits on the digital camera or film, then that's their copyright. They can sell that. If you wrote it, even if you wrote it and they then copied it on the copy machine, that copying is a violation of your copyright. The problem is, how do you enforce it? So that's where this comes in. It automatically comes into existence, which we talked about. Pen to paper, record sounds, shoot video, type a line of code. You don't need to register that. It automatically is your copyright, but you can't sue somebody else for infringing your copyright unless you register that copyright at the Copyright Office. Then that gives you a date that it was copyrighted. It shows that it's yours. Then when someone infringes, you can file a lawsuit. And copyrights are very inexpensive compared to patents. $65 for an application, and $35, they reduce it if you file it online. So they can be powerful. Filing it is what enables you to have the ability to sue. The date of registration can be more evidence of someone who copied it from whom, but if you can provide the evidence that you register it later, but you can provide the evidence that you're the original author and not them, then you can sue them for copyright infringement. Yes, you can't just go into court and say, well, Your Honor, I wrote it down, look. Well, who's to say that this person you didn't copy it from somebody else? You've got to have some evidence that proves to the court that you're the original author. Patents, the date is critical. And this is sort of the different rights that you can have. You have the right to reproduce it, to dictate who can copy it, so you can say, Joe, go down to the copy machine and run it off, and they're in the clear. This derivative work is interesting. If you, and there's some vague boundaries here, but let's say you look at a collection of poems. Well, let's just say that you have a bunch of different authors who have written different poems, and you put them all together as a derivative work, then you have a copyright on that collection. They each have copies. You've got to get permission from them to do it, but you are the copyright holder of the derivative work. And you've got to give them the ability you have the right to control whether they can distribute, sell copies, publicly perform it, or display it. Now, there is an exception to that, and I'm not going to give you any legal advice. But the basic idea is there's an exception in the copyright law that if you have, and you'll have to talk to your attorneys about this, but if you are teaching in a class and there's a limited amount of this copyrightable material that you're sharing, and it's a non-profit sort of an environment, then there are some ways that you can have fair use and you are not violating copyright law. It's a little complex, but right here is where you go at the website to read much about it. let's take it outside of the context of you teaching a class in a public facility, that's not a for-profit company. In a facility that it's a for-profit company, then you don't really get much chance to use that fair use exception. Now, what you've just said is very interesting because I hadn't thought about this before. If you cut it out and you copy it, then you're violating copyright. But if you put it under one of those projectors that takes the video and throws it up on the screen, I'm not sure. There are some different opinions about that, and they're not fixed. And if you go to that website, you can read lots about it. I'm sorry, I can't be more specific. Yep. The http://copyright.gov. So there's a whole section of the government that does this copyright, and then you can look up fair use and lots of other stuff about copyrights. Okay, and these are resources that I'll give this chart to the dean, and then we've already, Boeing is so strict on this stuff that I had to go through this process that they looked at this and reviewed it and made sure that I wasn't going to put any Boeing proprietary material in there, and I wasn't going to give legal advice. And then they've got a form that I've sent to the dean that says that you are authorized to copy this. Well, it used to be that before Bayh-Dole, that when the company funded you and you invented something, usually those contracts were pretty strict, or at least a 50-50 sort of arrangement, so that they had the ability, either licensed or owned, the ability to use what they had funded. After Bayh-Dole, it sort of shifted things around. So I can't really tell you, I'm not a Bayh-Dole expert. I can tell you what I know about copyleft, but I'm not an expert. So copyright is what you just saw, and that's, copyleft really is a software term. So we're talking about software and code that can be transported. So if you copy that code directly, then you've got it, and the owner hasn't given you permission, then you've violated copyright. But with open source standards and open source consortiums, some of those consortiums have said, we're going to write code, we're going to put it on the net, and it's freely available. They usually have some stipulations like, if you write some new code from it, you have to then put your new code up there, or something that doesn't cost you money because you use their original. Those are considered hard copyleft, and that's usually BDS, which is Berkeley, BSD, sorry, Berkeley. It may be an Apache, I can't be sure, but there's several there. And generally those were spun out of universities, and that's where that started. Then there's a sort of a middle copy, I don't know what it's called, copyleft, that has more restrictions to it. It's still open source, but you can't then just turn around and use it for whatever purposes you want. There's some restrictions on it. And each one of those groups has their own slight variations of those restrictions. Creative Commons, the way I understand it for Wikipedia, is hard left or copyleft, but you are supposed to, I think their stipulation is you're supposed to name the author. Okay, I think that's all. Thank you very much.